So if you're just tuning in here, court is in recess, Florida versus George Zimmerman. But the biggest news so far today, the no stand your ground defense. Zimmerman made the decision himself that he wasn't going to go there. But Mark, as we keep saying here, and maybe you can sort of explain it to us, yes, it made news, but it doesn't necessarily mean it's totally going to go away, right?
Right. If you listen to the motion that was made and the order that was entered, this was a pretrial immunity motion. Never said anything about trial. A pretrial immunity motion. So I think what you can anticipate is that O'Mara, on behalf of the defendant, is going to be asking that a stand your ground hearing be integrated, incorporated into the trial overall. One thing has been missed, and I think is very important. Why would it need to be done if they're really going on self-defense? Well, in Florida, if the motion is granted, then Zimmerman is immunized. He cannot be sued civilly. So if, in fact, they can proceed and get the judge to allow it to be brought into the course of the trial, and the judge were to rule with them on that, then that would prevent Zimmerman from ever being sued civilly when the trial is over. Because even if there's an acquittal, he can still be sued civilly. So if the stand your ground motion is granted, he can't even be sued civilly.
So then what does the defense then have to reveal before the trial if stand your ground is part of its plan?
Well, I think we're on some uncharted waters here. I just lost the sound, but I think that basically they have to bring it forth in the course of a motion, and then the judge would have to say that it's going to be held contemporaneous with the trial.
Gene, you were in that courtroom. We talked, they're saying let's make sure we talk more about what happened in that courtroom. So you tell me, because we haven't had a chance to chat with you about what you saw, witness. We talked a little bit about when Zimmerman did speak up, mentioned stand your ground, wasn't going to play at that moment. What else is standing out to you right now that we should be talking about?
Well, let me initially respond to what you were just talking about, because I think we heard procedurally how this would happen if the stand your ground hearing occurred during the trial. What I heard today in the hearing is that the defense would ask for it at the conclusion of all the evidence. So you've got a jury impaneled, you've got the case in chief, you've got the defense case, you've got the rebuttal case from the prosecution, and at that point is when the defense could ask. So the net result is you have a jury that's listened to an entire trial of evidence, but then they would not conceivably make the ultimate decision. In this case, it would be the judge. That would be fascinating. Now, the judge would have to agree to that. She would have to allow it to happen. I understand there is some precedent for having an immunity hearing within a trial, but I think that's how it would happen, the way I heard it here in the hearing today.
We're going to take another quick break, but the other thing we want to talk about, Gene, is the feistiness among lawyers today and the bizarre moment of when you had various lawyers going up on the stand against each other. We all were paying attention to that. We're going to talk about that next.